After Orlando, there is a renewed call for gun control in a recent appeals court ruling. Encouraging news here for the folks who believe that this country needs additional restrictions. Well, a circuit court in California, has just decided the restrictions on carrying concealed weapons are constitutional and that the Second Amendment does not provide a right to carry concealed weapons. Now, the Supreme Court could decide to take up this case. A UCLA law professor and gun law expert had this to say, quote, "This case raises the next great question for the Supreme Court. Does the Second Amendment guarantee a right to carry guns in public? And if so, what kind of licensing can states use to permit people to carry concealed weapons?" Now, that same professor, Adam Winkler, he just wrote an op-ed in the Times saying that it is time for a no-buy list for guns. And again, Winkler quoting directly here, "Congress should authorize no-buy lists, but mandate that appropriate protections be put in place if the Attorney General believes a suspected terrorist should be added to the list. The AG, she should have to go to court first and offer up evidence only after concluding that the AG has probable cause should the court approve the denial of a suspect's right to buy a gun." And on Capitol Hill, Senate Democrats, they've been filibustering all day today in their push to get gun bills onto the floor. They want expanded background checks and bans on people buying guns if, in fact, they are on the terror watch list. And in a strange turn of events, Donald Trump is going to be having a conversation with the NRA on this very subject, saying, well, maybe we can make an exception in terms of if you're on a terror watch list, should you be getting the gun? But barring that,
he's a great negotiator, so
absolutely,
he's going to fix it all up.
He'll make it great again. So, Mark, I ask you, the court decision that there was a 5-4 ruling before, and obviously this was when Justice Scalia was with us. If the court decided to take the case that I spoke about before, what could the consequences be, and what is the narrow that they've got to figure this through?
Well, first of all, I think there's very little likelihood that they're going to take the case for myriad reasons. The first reason being that there's no circuit split on the issue. I think it's pretty clear that Heller, which is the 2008 decision that Scalia wrote, that reinvigorated the Second Amendment, and that deals with the right to self-defense in the home. That's the core right protected by the Second Amendment, and this is obviously something very different. But more fundamentally, there's no appetite on the Supreme Court to revisit the gun issue in the wake of Scalia's death. There was another case about stun guns that you'll recall that was up in the court this term. They took an off-ramp rather than decide the issue. They issued a page-and-a-half opinion, sending it back to the lower court for more findings because of a legal mistake. It's clear they punted it. So with no circuit split, and with no appetite to get back into the thicket, this isn't going to the Supreme Court.
Let's say you're right in terms of on a docket, but on a principle issue. Heller basically explained what you can and can't do if you want to restrict it to your home. But when it goes outside the home, at the end of the day, if this does get litigated again, is it going to be what happens when you close your front door and you have on your person? Or is it going to be states get to decide here, you know, what kinds of guns? What's the threshold we'll be debating in this country?
In this ruling from the Ninth Circuit, they said categorically that the right to conceal carry is not protected by the Second Amendment, period. And I agree with that. They didn't get into open carry. What I would be arguing if I were the gun advocates, fine, I take your premise, I disagree with it. We can fight about that. The question is whether it impermissibly burdens, that restriction impermissibly burdens the core right to have the gun in the home for self-protection. Because if you can't carry it around anywhere, how are you even going to buy it and get it home to protect yourself? So that would be my argument, that it doesn't pass heightened scrutiny because it intrudes too much and cuts down too much on the right to have your gun in the home to protect yourself and your heart.
I think the answer to that, and I'm not sure if it was carved out, is that if you buy a gun and it's in the box and it's unloaded and you're transporting it to your home, that's one thing. You know, constitutional rights are not absolute in every respect. You may have a constitutional right to protect yourself and to carry a weapon in your home and to own a weapon. The manner in which you do so, though, is open to reasonable regulation that does not infringe upon the constitutional right.
In California, what they've made it, the next challenge in the case is going to be, because they also ban open carry. So open carry is banned, hasn't been litigated, its constitutionality. Concealed carry is now banned, and they can impose such stringent licensing restrictions as to fundamentally eviscerate and make it impossible to get the gun.
And
that
it
was
doesn't
what was the
prevent
problem
other
in
states
Heller.
from having lesser restrictions. I mean,
No.
there are other states where you see people walking around with their guns on their
I think
holsters.
I think that ultimately what would happen, I don't see any likelihood at all that there will ever be a federal statute outlawing concealed weapons. I think the federal government will leave it to the states to make their own determinations. However, we're talking about elephants and oranges. The elephant in the room here is not whether or not you should be permitted to carry concealed weapons. The elephant in the room, and that elephant has been ignored by Congress for years and years, is whether or not that anybody should be permitted to have an assault weapon.
Well,
If
there
you're
was an
not
assault
law
weapons
enforcement-
ban. It
Right.
lapsed, and this is what
That's
we're
right.
talking about.
And that because this mass shooting that took place in Orlando would never have happened if he did not have in his possession this assault weapon, which is a weapon of mass destruction. That's what it is.
Well, but the Supreme Court's gun jurisprudence and this case from March that they kicked back makes it very clear that the relevant question is not whether it's a military-style weapon or a pistol, not whether it was in circulation back in the day. So the assault weapons ban, it lapsed in 94 or something like that, long before Heller was even a glimmer in people's eyes.
It's funny. I've had on the set Trish Hayes, former Republican congressman from Connecticut, who co-authored the assault weapons ban that sunsetted, as you guys mentioned, after 10 years, from 84 to 94. Doug, he said, I'm not sure how much it changed, anything at the end of the day. But I went back and I read the Second Amendment. And I know this is a fruitless exercise because of all the politics involved and everything else. But nobody in their right mind is going to tell me that they ever intended for people to walk around with AR-15s.
That wasn't in his right mind? Because I agree with you. The text doesn't support
But
his
nobody
reading.
would have ever, first of all, if you read what the intent was versus where we are right now, I know the five legal minds at this table will tell me all the reasons why it doesn't make sense. And also the politics, I have a pretty good idea, and the lobbying. But nobody ever meant for something that was on the battlefield to now be in public consumers' hands. Why did we need a well-regulated militia? Well, the reasons back then and now are completely different.
Oh, I think we
But,
probably need a militia
but
more now than we did then.
Did you see what McConnell said? McConnell basically said that the Second Amendment was poorly written by the drafters of the Constitution
It's true.
because
That semicolon in there? It's
because they
crazy.
basically were only considering muskets. So, to McConnell's way of thinking, the people who drew the Constitution were too stupid to be visionary enough to anticipate assault weapons.
That may be true, but
Well, Sarah Silverman said
you are
that when it
talking
becomes
about a
electric,
constitutional
it's
right.
all over.
Right.
And then you could make these same arguments kind of about the First Amendment when talking about free speech. Nobody intended on people saying
Well, that's
these
right.
things.
The
now
point
they're-
is, it's not a secondary
well, the
right.
problem,
You're
the
you're
problem
exactly
is
right.
it's a constitutional right.
it's
People
not a
may not like
second-class
it.
right.
It may be ugly, but it's in the Constitution, so you got to deal with it.
And to Doug's point, really, the Constitution is a floor. Okay, so I mean, at some point, you can always restrict
I got to
beyond
hit
what
this
the
break here, guys.
Constitution does.
When we come back, Trump's hammered Hillary over deleting emails. You all know that. But the question, and you may have seen this story this week, did Trump do the exact same thing in one of, and I'm not making this up, his thousands of lawsuits? Is pot calling kettle black? Mark says no.